Alexandra Vargo with Colorado Legal Services. I am going to be doing a short video about civil protection orders here in the state of Colorado. We're going to go talk through what is a civil protection order, when you might need one, how you get one, and then some tips and tricks on being successful. So what is a civil protection order? It's going to be a document that protects you from another party. And once it's issued, it will pop up on the police system. It will be in the court system. It will also have some effect on certain types of jobs, as well as gun ownership, and we'll go through some of that. So why would you need one? The court has jurisdiction to issue one against any adult or against a juvenile who's at least 10 years old or more. We don't see a lot of them, at least here in El Paso County where I practice, that are with children involved. Usually they try and get, the school or the parents or someone else to sort of reach some resolution when there's children involved. But if you are over 10 years old or the party's over 10 years old, they can obtain a protection order if it's appropriate. The statutory options for protection order under Colorado Revised Statute 1314-104.5 are to prevent assault and threaten bodily harm, to prevent domestic abuse, to prevent emotional abuse of elderly or not risk adult, to prevent sexual violence, and to prevent stalking. So those are all the different options, and it does cost $95 unless it's a protection order related to domestic violence, sexual assault, or stalking. If it is one of those categories, then it doesn't cost anything. It is free. You're not required to have a police report, criminal investigation, criminal charges, anything like that. The protection order allegations can be based on things that have never even been reported. A lot of times the allegations are in fact about things that there's no other proof of, there's no corroborating evidence of, and it really just ends up being sort of like a he said, she said, or one person's word against another. Where can you file a protection order? That is very different from criminal cases where the incident has to have occurred in the county where you file. With a protection order, the venue is appropriate in any county where one of the acts has occurred, or any county where one of the parties resides, or any county where one of the parties is employed. So the statute is really in place to try and allow you to still be free and safe from the harm and the fear, and still be able to file your case. So the venue is pretty flexible there. I have got 4 slides in here about the legislative declaration. I'm not going to go through them word by word, line by line, but I think it's important for everyone to know who's practicing or helping with this type of law, as well as who's trying to get a protection order or defend against a protection order. The first goal is really to promote safety and reduce violence and abuse in the community. And the court was really trying to get a simplified process in place. Second is to really define domestic abuse, and specifically note that any domestic abuse can be really just something that's done with the intent to control and make a victim likely to return to an abuser for fear of retaliation or due to inability to meet their basic needs. So I think that's a more expanded version of domestic abuse than a lot of folks are aware of or might think about. So that's something that I certainly wanted to sort of include in here. But please do read through the rest of that legislative declaration, and go ahead and read through the Colorado Revised Statute 1314-100.2, which you can find online or at the library, or if your community has a law library like they do here in El Paso County, then that would be great as well. Number 3, the legislative declaration is regarding sexual violence. I did highlight a few things, which is this statute made clear it can occur in any type of relationship, as well as another reminder of just that it doesn't necessarily have to have been previously reported or previously litigated. And the last piece of the legislative declaration is about stalking. And I think that's important to know how common stalking is and how severe stalking is. There's a lot of incidents that happen here in Colorado where stalking can have folks end up in really obscure places, really places where there's no one around, where no one would hear them if they called for help. I've had some stalking cases, protection orders, where someone would like pop up on a hike in the middle of the woods, in the mountains. So things like that, I think, are just important to know. And also the effects of those stalking behaviors are really serious and affect all aspects of folks' lives and can really increase anxiety, depression, and other struggles that the victim of those types of behaviors experiences. So the timeline of a protection order case: you file the initial documents, you if it's granted, you serve the respondent. You have an ex parte hearing without the respondent. So ex parte means just one party, not the other. And then you have a return date or a permanent protection order hearing date. Initial documents, so the complaint, which is JDF 402, the affidavit regarding children, if there's children involved, is JDF 404, incident checklist 401, and information sheet 442. And I'll go through each of them in detail. The verified complaint for civil protection order is first. That's the major document. That's going to be where you're going to want to put all of the incidents that you want to allege at the hearing. So it's really important to make sure that you're including those events in here. If you think of things later, that's really helpful, but you're going to want to modify this complaint and include those other incidents later. Some jurisdictions around the state will let you include that additional information at your hearing, but often folks won't. They'll really restrict you to only talking about the things that were alleged in that initial complaint. So make sure that you're updating that as necessary as you sort of remember something or want to clarify something. So a few tips there. You just are going to have your basic information there, and to provide detail and specificity when you can, such as where, when, how did it make you feel? That's really important to put in there. Things like if someone was terrified to go back to their house, or someone felt like they couldn't leave, or someone felt like they had no way out, or something like that. And then specific requests, you can ask if the person be restricted from various addresses, such as work, school. You can clarify what contact you would like if you're okay with it. And then verified just means that you're like swearing that the facts are true. So that's why it's called a verified complaint. You actually have to sign it and say, yes, I promise that this is what happened and how it happened. Additional forms. The case information sheet is the second one. That's just super basic information. You describe the other party in there. So it'll ask you about height, weight, eye color, hair color, type of relationship, whether it was intimate and for what duration of time. If there are children involved, you want to fill out an affidavit regarding children. You're required to do that. It'll ask about other cases, such as a domestic violence case or a dependency neglect case or other maybe mandatory restraining order that protects the party or the children. The incident checklist is optional. I'm going to go into that a little more on the next slide. But I think it is a really helpful document. A lot of times when someone is asking for a civil protection order, there's a lot of incidents that have sort of been buried in their memories, or maybe blocked by some trauma, or they forgot, or maybe they don't realize is even a problem or a concern, or that it's not that serious. So the incident checklist that the court allows you to file with your initial forms is really, really helpful, and to ask specific questions like, has there ever been threat by physical, sexual abuse to the kids, threat to cruelty of animals, threat by following you, throwing things, grabbing you, shoving you, pushing you, all sorts of things. And this is about half of the page, just as an example. But I've noticed that when I have folks fill out this form, it really brings up some incidents and memories that maybe, were just kind of pushed away, or that the person just didn't think were that important, and actually they turned out to be really important. So then once those documents are completed, you're going to want to file them. You don't have to make copies. You just take the initial documents to the court. You can ask the self-help desk at your local courthouse for help. And they should be able to answer questions that you have, like about the specifics of the document. They won't be able to give you legal advice as far as like what's the best way to say this or something like that. they'll definitely be able to help you if you have questions about like what to put where, or what the expectation is, or how to file it, or things like that. In most counties, if they are filed by 9:30 in the morning, they can be heard on the same day. That may vary around the state, but oftentimes they are able to be heard same day. If not, it would be the next day. And then also many jurisdictions will allow a WebEx hearing for the actual hearing. If you need to leave before the case is heard, they'll accept your documents and schedule it and then give you the WebEx information. So the next step is that you go before the judge. So you'll have an ex parte hearing with the judge, and the other side won't be present. They won't be required to be notified before this hearing, for your conversation with the judge. All that they'll receive are those initial documents that you filed. And then your case will be assigned to a courtroom. Again, hopefully the same day or the next day. Be patient, because some days there's a whole lot of other folks asking for protection orders, and they kind of have like a cattle call. So everyone's going to be coming into the courtroom for that same time frame, and they'll go through each case. Some courtrooms will kind of do like the ones that they know they're denying first and get them all out of the courtroom, and then go through the ones that are being granted and give all of those folks sort of a summary of what's next. But I think the judges kind of vary on how that works. So if yours is granted, the next step is service. So you do have to have the other party personally served with a protection order. Anyone over 18 who's not a party can serve them. And the sheriff's office will do protection orders that are based on domestic abuse, sex abuse, or stalking for free. So I generally encourage folks to have the sheriff's office serve these, unless there's some reason you wouldn't want to do that. If you do have a known address, definitely have the sheriff do it, and then bring proof of service to the court date. If you have someone serve the other party, even if it's the sheriff, and they say, you know, we'll file it with the court, or we dropped it off, or whatever, go ahead and just bring a copy. Sometimes things do get filed, but maybe they're not yet available to the judge in the system, or something wonky happens. So if possible, just bring that paper copy of the proof of service to court when you go. And that can be really helpful to keep the case moving along. So what they'll do at that ex parte hearing, where you talk to the judge, if it's granted, they will schedule you for a return date, also known as the hearing date. And so generally, none of these cases are actually going to hearing on that day. It's going to be the first appearance of both parties. So it's going to be the date that the other party was provided to appear. But I still call it a hearing date because if the other party doesn't come, you can ask for your protection order to be made permanent, and the judge will grant that. So the other party doesn't show up, this can be your hearing date, your final date. You can get your permanent protection order. If both parties do show up, you might not be able to go forward, or you might not be ready. You might want more time. They might want more time. And the statute does allow up to 14 days for each party for a continuance. So if you show up and the other party says, I want to go get a lawyer, or get some exhibits or whatever, they can have up to 14 days. Again, same thing goes for you. So if you say, I need a little bit more time, then you can have the 14 days as well. And if the parties agree to longer than that, you're welcome to. So parties can agree to maybe like 30 days to get their witnesses or exhibits ready, or sometimes maybe to try and work on some agreement, something like that. But if everyone is ready and the court doesn't have anyone else scheduled to go first, then the case can proceed to a hearing. So a few reminders: don't be late. The doors are usually locked until the time that the hearings are scheduled. If the respondent doesn't show up at all, petitioner wins. So if you're a respondent, if you're served with these documents, make sure you show up to court, make sure you show up on time, because otherwise it will be granted without you, and that permanent protection order will be on your record until you take some steps to try and get rid of it if you can. And then if you don't have proof of service yet, you can ask the court for continuance, and they have to allow that for you to attempt to serve the other party. In the courtroom, just generally, this might be basic, but petitioner usually sits on the left, respondent sits on the right. The petitioner is the person who files the complaint. The respondent is the person served with the documents. The judge is up in front. There's usually a clerk on one side or the other. And then sometimes there's other parties in the courtroom, like other clerks or other support staff. You do have to have a hearing the burden is preponderance of the evidence. So you have to prove that more likely than not, the respondent, so the party who you're trying to be protected from, if you're the petitioner, has committed acts constituting grounds for the civil protection order. So you have to prove that the things you said in your complaint really did happen. And then the second part is, unless restrained, the person will continue to commit those acts or acts designed to intimidate or retaliate against the protected person. And that is the piece that's a little bit tricky, where sometimes you do have to have proof of sort of prior lack of compliance or something like that. And I'll dig into a little more about evidence and proving your case. Some general tips: you're going to want to consult the Colorado Rules of Evidence. You're going to want to practice ahead of time. Make sure you bring 4 copies of everything, one for the judge, one for the witness, one for yourself, and one for the other side. You want to know specific dates and times of the incident. Make sure that you're organized. I like to encourage folks to do a timeline, like really just like a bullet point timeline of major incidents, the ones that you allege in your complaint, and also others in case the other party brings up other incidents. And then you want to tell the judge your story so that they can imagine it. So you want them to be able to sort of picture it and, like really feel like they were there, feel like they could feel the fear or feel the feelings that you were feeling during that time. You want to focus on the facts and experiences. So you're not going to want to say things like, well, they're a big jerk or they're a monster, nothing like that. You're going to want to really focus on like, this person did this, and this is how I felt, and this is how I feel, and this is why I need this court's help to keep me safe. So that's really kind of the tone that you want to have with the court. Is really just a fact-based and telling your story. And there are strict time limits in these hearings. A lot of them are awfully short, like maybe 30 minutes per side or something. So if you think you might have, a bunch of witnesses or a bunch of exhibits or something, you may need to ask the court for additional time, otherwise you're likely to run out. Examples of evidence: telling your story, so your direct testimony, their story, and cross-examining them. So after the other party talks, you can ask them questions, or your attorney can if you have an attorney. Other witnesses are going to need to be people who saw or heard the things that happened, or maybe who you directly reached out to after something happened, not just like character witnesses or people to come say like, you're not a liar or they are a liar or something like that. It's not going to be helpful. You want witnesses who were directly related or directly aware of the incident that you alleged in your petition. Videos, audio recordings, documents can be helpful if they're between the two of you, like if maybe they wrote you like a threatening letter or something like that. But if it's a document from a third party, maybe like a medical document or something from a school, something like that, that document's not going to be admissible. It's going to be hearsay unless you have the person who wrote it as a witness or unless the parties agree to let it in. So be careful with documents. Text messages are also great especially if they're between you and the party. If they're between you and someone else, or the other party and someone else, you may need that other party in order to get a text message in. The Brady Bill applies, which is related to guns. So if a protection order is based in whole or part on domestic violence and involved a threat of use of physical force or attempted use of physical force, they must refrain from possessing or purchasing firearms or ammo during the duration of the order. Failure to do so could lead to arrest, and this is enforced extremely strictly. So once the protection order is in place, the other party will have to fill out an affidavit regarding weapons and regarding guns. And if they don't fill it out, a warrant will be issued for their arrest. If they do fill it out and it turns out maybe they're not complying with it, which can come up sometimes, then that also would lead to some sort of follow-up steps depending on the situation. If there are children involved, you're going to want to ask for care and control clauses in your protection order. And the court must include those if you ask for them, but the court will decide what's appropriate. And those can be for a year, up to a year, and only if the district court doesn't already have jurisdiction. So if there's not a custody or divorce case, you're going to want these care and control orders. And they can be about parenting time, conditions on parenting time, supervision, and then also the court should award decision making when it's reasonably related to preventing domestic violence or preventing the kid from witnessing domestic violence. Again, a period of not more than 1 year. So the court can't require you to go do a custody or divorce case, and that's specifically in the statute as of January 1st of this year of 2025. Prior to that, it was, I would say, pretty standard for some judicial officers to say, well, just go file a DR case, just go figure it out there. That's not for this courtroom, things like that. And there's really been some pushback on that because a lot of these orders are really important to keep kids safe. And sometimes you can't get into, even if you did file a custody or divorce case, your first hearing may not be for weeks or months. So they did make it so that the judges do have to enter these orders if they're requested. So that's a really important thing to remember in your protection order. Again, if there's children involved, you're going to want to clarify what that parenting time and communication will look like. There's some examples on here of how you can clarify contact. Many folks use Talking Parents or Our Family Wizard or some other sort of communication app. Text messages sometimes regarding the children, but some folks are, it's a little easier to delete or modify messages that way. So I encourage folks to use Our Family Wizard or Talking Parents if they are only communicating in writing. And then if exchanges, just be sure you're being thoughtful about those. And then you're going to want to clarify if parenting time, if it's happening, if it's supervised or unsupervised. A little more about exchanges. It's important for them to be safe. So you want to make sure that the exchange zone or the way that exchange works is going to be the least stressful to the child and the most safe. So somewhere in a public place is usually recommended and preferred. Sometimes like through a third party works, but sometimes third parties, whether or not they're sort of non-biased at the beginning, can kind of end up being caught in the middle of a bunch of drama. So I usually encourage someone to use a visitation center such as CASA or private supervisor if there's supervised parenting time. The police station parking lot or inside of the police station building can be a really good spot. Same with the fire station. If the police station is kind of intimidating, maybe to kiddo or feels a little icky for some reason, a fire station, there's always someone there. So that can be a good option as well. And fire stations can be like a little more fun for kids or like seem a little more exciting. And then public places, malls, parks, I like libraries. They usually have a good camera system. They also often have a metal detector. Some folks will do like the Starbucks inside of a Target or something like that, so that there's a little bit of normalcy, but also a little bit of supervision and safety. So back to the protection order hearing. What if you lose? What if you get denied at your initial request? So when you go in for that ex parte hearing and you haven't served the other party or anything, and then the judge says no, usually at that point, they will tell you why, and you can sort of beef up your complaint or wait till another incident happens, which isn't ideal, but sometimes the initial complaint just doesn't have everything that you need in it. So sometimes it's as easy as a modification. Sometimes it's going to need an additional allegation or something like that. And if it's dismissed at that point, it will be dismissed without prejudice, which means that you can file it again with the same facts. Really as many times as you need to. It happens also if you just can't find the other party, let's say they escaped town, left the state, are really just like totally avoiding service. You can't do publication or any other type of service in these cases. You must have personal service. So if you can't get service, the court will dismiss it without prejudice, and then you can file again once you think you can serve them, or maybe sometimes this is you can overcome this if they pop up in jail. You can refile and get them served really quick by the sheriffs. Or if they've got like a court date in a few months, you can refile right before that court date, have them served at court, things like that. If you couldn't make it to court on time and the judicial officer dismissed the case, again, without prejudice, so you can ask again and make sure that you're sort of getting rid of any barriers that you have in place. If you do have a full permanent protection order hearing and then you lose at the completion of the evidence witnesses, then it will be dismissed with prejudice, which means you don't get to try again with those same facts. But it doesn't prevent you from filing in the future if things keep happening. So that's a little bit about what happens if you lose. There's usually some other options, some other ways to get the protections down the road. And then that's pretty much it for civil protection orders in a nutshell. Again, this is my office, Colorado Legal Services. We have offices around the state. We cover every county in the state of Colorado. And here is my contact information. If anything comes up, if you have any specific questions, if you're a resident, trying to get a protection order or something like that, you could apply with our office. Sometimes we're open for intake. Sometimes intake is closed depending on what resources we have and what funding we have. Sometimes we have other resources or referrals we could send you. If you're working with folks in the community trying to help others get protection orders, you can also reach out to me if you have any questions or concerns. So thank you so much for listening, and wish you the best.